I picked up a new case.
Um, April 22nd, 2025, officer dispatch in reference to a
All right, buckle up, new case. Same chaos energy. Anytime you hear, picked up a new case, while someone's already out on bond, that's already a red flag, triangular flag. Question for you. Do you think this is just bad luck or a pattern starting to form?
in reference to earlier a motor vehicle. Complainant stated that at 4:30 a.m. she heard a car alarm go off and looked out the window and saw two individuals leaving.
Oh my God, you're telling me this is a BMV?
No, it's not being beer.
That's the co-defendant,
It's the
Judge.
defendant.
She's with. This is a party.
Not charged though, Your Honor. Say that, but
And just like that, we've escalated from car alarm to straight up threats. This is where things start stacking legally. Possible trespass, threats, and now intent. Courts love patterns, and not in a good way. Would you consider that statement just frustration, or something more serious?
complainant approached the suspect and defendant Silva stated that she was, quote, going to beat her ass if she kept following me. The complainant was able to flag down an officer. And the defendants, the other complaining witness, the owner of the vehicle, said that the officers, there was a red paint on the front seat of the complainant's motor vehicle.
Okay. This is what we call physical evidence lining up a little too perfectly. Paint in the car, paint on the bike, paint on the clothes. That's not coincidence. That's a breadcrumb trail. If you're the judge, are you thinking maybe or case closed?
Complainant observed that a bike that defendant Silva was riding on had red paint on the seat, and the back of defendant Silva's pants was also red paint. During the investigation, I observed defendant Silva with red paint on the back of her pants. During the investigation, defendant Silva admitted to going to the vehicle to find things changed. Once the defendants were detained, officers asked what the defendant's name and date of birth was. She first stated that her name was Sierra Johnson, date of birth 4/18/2002. Officers asked for a clarification on the spelling.
Oh, and here it is. False identification. This is where things go from bad to worse fast. Giving a fake name to law enforcement? That's its own charge. At this point, the credibility is taking a serious hit. Be honest, does anything she says after this feel reliable?
Officers then asked if she ever had a Texas driver's license or ID. She stated she did not. Officers ran the given name, but nothing came back. Officers then called for Motive Avis. While officers were waiting, he asked the defendant what her name was, and she said that her name was spelled Sierra, Ceirra, with a C instead of an S, and that Johnson was her mom's last name, and that her real name was Torrance. Officers ran the new name and Texas driver's license, came back to defendant Torrance with multiple City of Houston Precinct 2 warrants.
So the co-defendant got charged.
The defendant was charged, Your Honor. I'll pull it up now.
Why not Miss Torrance?
Notice how even the court is dancing around the why. That usually means there's more going on beneath the surface, either evidentiary gaps or strategic decisions. Judges hate incomplete stories. And when they sense something deeper, they start digging.
From what I could read in here, Judge, I don't want to speculate, but I think all of the evidence can point to the co-defendant. And in fact, co-defendant admitting to going into the vehicle.
There was red paint in the car.
Right.
She has red paint on her.
That was.
No, that was I don't.
Was she acting as a lookout?
I don't know why you did not take a B&B on this. I don't want to speculate. All I can see is that obviously there was a decision made and take that they didn't have enough for B&B, but they had.
Anna, as much as I love you and as much as I appreciate your tenacity, no, there's something going on that's a lot deeper with this, and I'd like to find out. And what I'd like to do is have her T-rest, essentially. But I don't know what we need to do to get through to you, Miss Torrance, but apparently of all the stuff that we've dealt with now in your case is what? 241 days, and yet we
Judge, if I may, this is a DWI. We got the alcohol report back and they sent it off to get tested for tox. We still do not have that toxicology report. And when we were,
I get it.
okay,
I'm not saying
it's just, she's not the one dragging it out. It's been waiting on the test.
you are on
Yeah.
bond. You've now picked up a new case. I've repeatedly asked you to behave yourself while on bond. That you are not charged with 2 cases and you merely have the one. I'm now revoking your bond number. It's DWI.
And there it is, the hammer drops. Bond revoked. This is huge. When a judge revokes bond, it means trust is officially gone. From a legal standpoint, this is the court saying, you had your chance. Do you think this was inevitable, or could this have been avoided?
And I'm taking you in. And what I'd like to do is have her TRAS
Okay.
immediately to
Okay.
see how we go forward, because this is, in my opinion, throwing her to the wolves, because something is going on and I'm going to try to nip it before it becomes felonious.
Judge, we do have an alternative offer on there. That would include the TRS.
I want to do it first
Absolutely.
so we see how to go forward, because I don't want,
And while we're here, actually, let me talk to the state about
a year in
this.
jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
Thank you, Your Honor. On April 20th, 2025, in Harris County, Texas, law enforcement officers were dispatched to a report of erratic driving in a gray BMW sedan, nearly striking other vehicles. The law enforcement officer located the vehicle and paced the vehicle going 85 miles per hour and a 65 mile per hour.
Hey, don't talk. Don't talk. Can you start from the beginning, please?
Yes, Your Honor. On April 20th, 2025, in Harris County, Texas, a law enforcement officer was dispatched to a report of erratic driving of a gray BMW sedan, nearly striking other vehicles. The law enforcement officer located the vehicle and paced the vehicle going 85 miles per hour in a 65 miles per hour zone and saw the vehicle almost strike a delineator pole. The law enforcement officer initiated a traffic stop and made contact with the defendant. The law enforcement officer observed a strong odor of an alcoholic beverage, slurred speech, red glossy eyes, swaying, and unbalance from the defendant. The defendant admitted to having 2 beers prior to driving, or 2 alcoholic beverages unspecified prior to driving. Standard field sobriety tests were conducted. A 6 out of 6 on the HGN, a 5 out of 8 on the walk and turn, a 2 out of 4 on the one-leg stand. The law enforcement officer found an open container of an alcoholic beverage on the passenger side floorboard, cold to the touch. The defendant consented to breath and blew a .137 and a .127.
Mr. Walker, I'm going to find that there's sufficient probable cause to go forward with the case. I am now taking away your ability to drive. You are not allowed to drive. Do you understand? You will be signing an affidavit with me today, promising me you're not going to drive. I don't give a rat's behind what your excuse is. If I find that you drive, I can have a contempt hearing. You can be facing an additional 6 months in jail and a $500 fine every time you drive. Do you understand? Because it's a second offense, I'm requiring you now to get a portable device that you're going to take with you everywhere you go to prove to me that you're not consuming alcohol. If I find that you do, I will put you in jail. No more PR bonds for you. Do you understand? You're not to consume alcohol, illegal drugs, unprescribed controlled medication. I'm going to randomly test you. Does he have a license? Can you run it?
Yes, Your Honor.
We're going to reset your case to give you time to hire a lawyer. So I'm going to have you come up here, swear to us that you're not going to drive. I'm going to get you to Victoria, where we will have you sign a reset. You will then get with pre-trial for your bond conditions, and after that, you'll be free to go. When you come back, please have a lawyer. please.
Your Honor, we have the license and eligible.
Is that the last one?
Judge, that is, for now, yes, I think I have 2 of them set for arraignment with the attorneys that are reviewing.
Okay. Mr. Walker, or do finish that, and then I want to tell you something else. Oh, hold on, Vic. Let me tell Mr. Walker one more thing. Come up. I am placing a restriction on your license. You are not allowed to drive any vehicle that doesn't have an ignition interlock on it. I'm sending notice to DPS in Austin so that every single officer in the state knows that if you're in a vehicle driving, that vehicle is supposed to have an interlock on it. If you're caught and you don't have one, they will take you to jail. As it stands now, as part of your bond conditions, I'm warning you not to drive for the time being. Do you understand? Look, it's not, I'm just, no response is required. I'm just telling you what the expectations are. And if you violate these conditions of bond, I will revoke the bond and I'm going to put you in jail.
I know, I'm trying to get a real good understanding. That's why I want to ask the question.
You need a lawyer. I don't want you to ask something. I don't want you to say something that hurts your case. We're going to give you time, please.